चालू करती है. Hello everyone. What are the powers of the court when the case comes before it in appeal? This is what we are going to discuss today with the help of two provisions, 107, section 107 of the Civil Procedure Code, and also along with that order 41 which speaks about the procedures. We have looked into some provisions now relating to the powers and functions. We will be discussing it further. Now, the powers of the appellate court under section 107 can be discussed under 6 heads. Okay. Of course, these grounds are stated in section 107 itself. First of all, the power is to determine a case finally. When a case comes before it in appeal, the appellate court will finally make a decision on that particular case. ಒಂದು ಕೇಸು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ ಅಪೀಲಲ್ಲಿ ಅದು ಮುಕ್ತಾಯ ಆಗಬೇಕು, ಕೊನೆ ಆಗಬೇಕು ಅಂತ ಅದರಲ್ಲಿ ಒಂದು ನಿರ್ಣಯ ಕೊಡೋದು ಪವರ್ ಇದೆ. ಟು ರಿಮಾಂಡ್ ಎ ಕೇಸ್ ಮೀನ್ಸ್ ಸೆಂಡಿಂಗ್ ಬ್ಯಾಕ್ ದ ಕೇಸ್ ಟು ದ ಲೋವರ್ ಕೋರ್ಟ್. ಸೊ ದಟ್ ಈಸ್ ದ ಸೆಕೆಂಡ್ ಪವರ್, where the appellate court, if it thinks fit, can send it back to the lower court or to the trial court. Then it has a power to frame issues and refer them for trial. In case it thinks that some issues are not framed, then the appellate court can refer them for trial. ಯಾವುದೇ ಒಂದು ವಿವಾದದ ಪ್ರಶ್ನೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದನ್ನು ಫ್ರೇಮ್ ಮಾಡಿ ಮತ್ತೆ ಅದನ್ನು ರೆಫರ್ ಮಾಡೋ ಪವರ್ ಇದೆ. ದೆನ್ ಟು ಟೇಕ್ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಆರ್ ಟು ರಿಕ್ವೈರ್ ಸಚ್ ಎವಿಡೆನ್ಸ್ ಟು ಬಿ ಟೇಕನ್. ಮತ್ತೆ ಏನಾದರೂ ಸಾಕ್ಷಿ ಬೇಕಾದರೆ ಆ ಸಾಕ್ಷಿ ತಗೋಬೇಕು ಮತ್ತು ಆ ಸಾಕ್ಷಿನ ತಗೊಳ್ಳೋಕ್ಕೆ ಆದೇಶ ಕೊಡುವಂಥ ಪವರ್ಸು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಇದೆ. ಇಟ್ ಹ್ಯಾಸ್ ಆಲ್ಸೋ ಪವರ್ ಟು ಮಾಡಿಫೈ ದ ಡಿಕ್ರಿ ಅಂಡರ್ ರೂಲ್ 33. ಆ ಡಿಕ್ರಿಯನ್ನು ಮಾಡಿಫೈ ಮಾಡಿ ಚೇಂಜ್ ಮಾಡೋ ಪವರು ಅಪೆಲೇಟ್ ಕೋರ್ಟಲ್ಲಿದೆ. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಪವರ್ಸ್ ಇದೆ, ಅದು ಏನಿದೆ ಅಂತ ನೋಡೋಣ. ವಿ ಆಲ್ಸೋ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ದ ಅದರ್ ಪವರ್ಸ್ ಆಫ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ನೌ ಫಸ್ಟ್ ಒನ್, it is to determine a case finally. This is rule 24 section 107 subclause 1a. Now suppose when the appellate court looks into the case which comes to it for appeal and it thinks that the evidence which is there on the record, looking into that, it is enough or it is sufficient that it can determine the case finally, not going to any other details. ಯಾವುದೇ ಒಂದು ಕೇಸ್ ಮುಂದೆ ಬಂದಾಗ ಅದನ್ನು ಈ ಎವಿಡೆನ್ಸ್ ನೋಡಿದಾಗ, ಸಾಕ್ಷಿ ಎಲ್ಲ ನೋಡಿದಾಗ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಅನಿಸುತ್ತೆ ಇದ್ರ ಮುಂದೆ ಏನು ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ, ತಕ್ಷಣವೇ ನಿರ್ಣಯ ಕೊಡಬಹುದು. ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಅದನ್ನು ಜಜ್ಮೆಂಟ್ ತಕ್ಷಣ ಕೊಡಬಹುದು. ಆದರೆ ಈ ಬೇರೆ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಬೇರೆ ಗ್ರೌಂಡ್ಸ್ ಇರ್ಬೋದು, ಯಾವ ಆಧಾರದ ಮೇಲೆ ಅದನ್ನು ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದೆ ಅದು ಬೇರೆ ಇರ್ಬೋದು. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಗ್ರೌಂಡ್ಸಲ್ಲೂ appellate court ಅದನ್ನು ಡಿಟರ್ಮಿನ್ ಮಾಡ್ಬೋದು. ಸೊ ದ appellate court is not bound by for deciding that case on a particular ground only. If it thinks that there are some other grounds on which it can be decided, it may finally determine the case, notwithstanding that the trial court has proceeded on some other ground and the appellate court is proceeding on some other ground. There is a case for this, Bhairab Chandra versus Ranadhir Chandra. This was a case for eviction. It was a suit for eviction, All India Reporter 1988, where the person filed against his tenant. He filed a suit for eviction saying that he needed that particular building or that particular premises for his own occupation and that he wanted it for further requirements. He was already staying in one part of that building. So the other party contended that he already is staying in that premises, so he need not he need not ask for eviction because that is for the place which he has given for rent. Besides that, he is having one more place which he has also which he can also occupy. Now looking into the facts of the case, here what happens, all the evidence is taken by the court and the court says that there is no need to disturb the decree of the lower court, because all the facts are clear. So, when the facts are clear, see, the only thing what has to be decided is whether according to the case what he has contended, that I need to occupy this for my purpose. So, looking into the fact the trial court has given complete reasons, ಆ ಕೇಸಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪೂರ್ತಿ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿರುತ್ತೆ, ಯಾವ ಸಂಗತಿಗಳಿದೆ ಆ ಸಂಗತಿಗಳ ಬೇಸಿಸ್ ಮೇಲೆ ಅವನಿಗೆ ಬೇಕಾಗಿದೆಯೋ ಅಂತ ಎಲ್ಲ ನೋಡಿ ಅದ್ರ ಮೇಲೆ ಒಂದು ಡಿಸಿಷನ್ ಕೊಟ್ಟಿರುತ್ತೆ. ಇಟ್ ಹ್ಯಾಸ್ ಡಿಸ್ಮಿಸ್ ದ ಕೇಸ್, ಬಟ್ ಹಿಯರ್ ದ ಅಪೀಲ್ ಈಸ್ ಅಲೌಡ್ and the court says that when the facts are clear, we need not go to any other details or call for any additional evidence or remand the case for the trial courts once again to look into it. Not necessary, it is immediately being determined. So, immediately the appeal is allowed, and the court says in this case that under Rule 24, when all the evidence on record is sufficient, then it can be proceeded on some other grounds. What is that some other grounds? In this case, the court says that the lower court has decided on the ground that he is having, see, it is a ground of fact only, it is a question of fact. So, he is already having a particular place for him to live, but the appellate court distinguishes that and says that even though he has some other place to live, there are some other facts also in that case which shows that he needs it for his further occupation. So, therefore, the court looks into the whole facts and gives a reason which is not the reason given by the trial court. So, this is a very good case to look into Rule 24. Now, the next is to remand a case, that is to send it back. Second power ಏನಿದೆ, ಆ ಕೇಸನ್ನು ಕೆಳ ಕೋರ್ಟಲ್ಲಿ ಮತ್ತೆ ವಾಪಸ್ ಕಳಿಸಿ ಅವ್ರ ಕಡೆಯಿಂದ ಅದನ್ನು ಡಿಸೈಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು. ಅದು ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾಡಬಹುದು? ಸಿ, ವಿ ಹ್ಯಾವ್ ಟು ಲುಕ್ ಇನ್ ಟು ದ ಕಂಡೀಷನ್ಸ್. ನೌ ದ ಪವರ್ ಟು ರಿಮಾಂಡ್ ಇಸ್ ಸ್ಟೇಟೆಡ್ ಅಂಡರ್ ರೂಲ್ 23, ವೇರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಡಿಸೈಡೆಡ್ ದ ಸೂಟ್ ಆನ್ ಎ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ and has not recorded findings on other issues. What happens is, when the case comes before the court, sometimes it is preliminarily dismissed or preliminarily allowed, whatever it is. If it is allowed preliminary, then what happens? It goes on to the next stage, and then the final decree comes in. But preliminary point, any preliminary point is looked into the court and thinks that no other findings are required, and it passes the it decides the suit. In such case, the person can go in appeal to the appellate court, and the court may direct the trial court, the appellate court may direct the trial court to decide other issues and determine the suit. ನೀವು ಬೇರೆ ಇಶ್ಯೂಸ್ ಡಿಸೈಡ್ ಮಾಡಿಲ್ಲ, ಬರೀ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ ನೋಡಿಕೊಂಡು ನೀವು ನೀವು ಈ ಕೇಸನ್ನು ಡಿಸೈಡ್ ಮಾಡಿದ್ದೀರಾ, ಅದನ್ನು ಮತ್ತೆ ಬೇರೆ ಇಶ್ಯೂಸನ್ನು ಟ್ರೈ ಮಾಡಿ ಅಂತ ಹೇಳಿ ರಿಮಾಂಡ್ ಮಾಡ್ಬೋದು. ಇದು ಸಾಮಾನ್ಯವಾಗಿ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ ಅಂದರೆ ಏನು ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕು. ಸಾಮಾನ್ಯವಾಗಿ ಒಂದು ಪ್ರಾಥಮಿಕ ಒಂದು ಪ್ರಶ್ನೆಯಲ್ಲಿ ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿರುತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಸೊ there is also another power, that is, even if it has not dismissed on the preliminary point and the lower court has decided on merits, then also if the appellate court thinks that remand is necessary in the interest of justice, ಅದು ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟಲ್ಲಿ ಎಲ್ಲ ಬೇರೆ ಎಲ್ಲ ಮೆರಿಟ್ಸ್ ತಗೊಂಡು ಬೇರೆ ಎಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ತಗೊಂಡು ಹಳೆ ಕೋರ್ಟ್ ಕೆಳ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡಿದೆ ಅಂದರೂ ಕೂಡ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಏನು ಮಾಡ್ಬೋದು, ಅದನ್ನು ಇನ್ನೊಂದು ಸತೆ ನ್ಯಾಯದ ಹಿತಾಸಕ್ತಿಗಾಗಿ, ಇದನ್ನು ಜನರ ಹಿತಾಸಕ್ತಿಗಾಗಿ ಇದು ಬೇಕಾಗಿದೆ ಮತ್ತು ಇದನ್ನು ರಿಮಾಂಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಅದನ್ನು ವಾಪಸ್ ಕಳಿಸ್ಬೋದು. ಸೊ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಕನ್ಸಿಡರ್ ದಟ್ ಇಟ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಇನ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಆ್ಯಂಡ್ ಸೆಂಡ್ ಇಟ್ ಬ್ಯಾಕ್ ಟು ದ ಕೋರ್ಟ್. So these are the two conditions. So let us see how this order of remand is done. See, by passing an order of remand, what is the nature of that remand? When you look into that, see, when the remand is done, the lower court is directed by the appellate court that it should retry the case, reopen the case and retry. ಸೊ ಇನ್ನೊಂದು ಸತಿ ಆ ಕೇಸನ್ನು ಓಪನ್ ಮಾಡಿ ಇನ್ನೊಂದು ಸತಿ ಅದನ್ನು ಟ್ರೈ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಬರುತ್ತೆ ರಿಮಾಂಡಲ್ಲಿ. ಸೊ ಆವಾಗ ಏನಾಗುತ್ತೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದನ್ನು ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋಬೇಕು ಆ ಸೂಟನ್ನು. ಒಂದು ಒರಿಜಿನಲ್ ನಂಬರ್ ಏನಿರುತ್ತೆ ಆ ಸೂಟದು ಅದೇ ನಂಬರಲ್ಲಿ ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಅದನ್ನು ಮತ್ತೆ, ಯಾಕೆಂದರೆ ಒಂದು ಸತಿ ಅದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿರುತ್ತೆ, ಸೊ ಮತ್ತೆ ಅದನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಯಾವ ರೀತಿ ನಿದರ್ಶನ ಕೊಟ್ಟಿರ್ತಾರೆ ಅದ್ರ ಪ್ರಕಾರ ಅದನ್ನು ನಿರ್ಣಯಿಸಬೇಕಾಗುತ್ತೆ. ಸೊ ವೆನ್ ಇಟ್ ಇಸ್ ಎ ಆರ್ಡರ್ ಆಫ್ ರಿಮಾಂಡ್, it goes to the lower court. The lower court will readmit the suit and it will proceed to determine it as per the directions. The whole directions are given by the appellate court when it goes for remand. So that is the scope of remand. Then the suit should be disposed of, we said, then only remand can be ordered. So on what ground? On a preliminary point. So if it is disposed of on a preliminary point, then remand can be ordered. Secondly, if the appeal goes to the appellate court, there should be some reason where the appeal must be reversed. If the appeal is not reversed or it is confirmed as it is, or the case is confirmed as it is, then remand cannot be done. So the condition is that it must be reversed. The appellate court ge idu reverse ಮಾಡಬೇಕು ಅಂತ ಅನಿಸಬೇಕು. ಅದೇ ಡಿಸಿಷನ್ ಹಾಗೆ ಇಡಬೇಕಾದ್ರೆ ರಿಮಾಂಡ್ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಸೊ ಇಟ್ ವಿಲ್ ಫಸ್ಟ್ ರಿವರ್ಸ್ ದ ಡಿಕ್ರಿ ಆ್ಯಂಡ್ ದೆನ್ ಇಟ್ ವಿಲ್ ಸೆಂಡ್ ಇಟ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆ್ಯಂಡ್ ಇಟ್ ಶುಡ್ ಬಿ ಶ್ಯೂರ್ ದ್ಯಾಟ್ ಇಟ್ ಶುಡ್ ಬಿ ನೆಸಸರಿ ಟು ಆರ್ಡರ್ ರಿಮಾಂಡ್ ಇನ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಜಸ್ಟಿಸ್. ನ್ಯಾಯಕ್ಕೋಸ್ಕರ ಇದು ಬೇಕಾಗಿದೆ ಅಂತ ಅನ್ನಿಸ್ಬೇಕು, ಇದು ಅವಶ್ಯಕ ಇದೆ ಅಂತ ಹೈಕೋರ್ಟ್ಗೆ ಅನ್ನಿಸ್ಬೇಕು ಅಥವಾ ಹೈಯರ್ ಕೋರ್ಟ್ಗೆ ಅಥವಾ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಅನ್ನಿಸ್ಬೇಕು. ಆವಾಗ ಅದು ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಮಾಡುತ್ತೆ. ಸೊ ದೀಸ್ ಆರ್ ದ 3 ಕಂಡೀಷನ್ಸ್ ವಿಚ್ ಆರ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್. ವಾಟ್ ಈಸ್ ಅ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್? ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ ಅಂದರೆ ಏನು ಅಂದರೆ, ಯಾವ ಪಾಯಿಂಟದ ಮೇಲೆ ಆ ಪೂರ್ತಿ ಸೂಟು ಯಾವುದೇ ಪಾಯಿಂಟ್ಸ್ ಕನ್ಸಿಡರ್ ಮಾಡದೆ, ಯಾವುದೇ ಬೇರೆ ಪ್ರಶ್ನೆಗಳನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡದೆ ತಗೊಳ್ಳದೆ ಅದನ್ನು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಬಹುದು ಅಂತ ಯಾವುದಾದ್ರೂ ಪಾಯಿಂಟ್ ಇದ್ದರೆ, ಇಫ್ ದರ್ ಇಸ್ ಅ ಪಾಯಿಂಟ್ ಆನ್ ವಿಚ್ ಎ ಡಿಸಿಷನ್ ಈಸ್ ಗಿವೆನ್ ಆ್ಯಂಡ್ ಇಟ್ ಈಸ್ ಸಫಿಷಿಯಂಟ್ ಟು ಡಿಸ್ಪೋಸ್ ಆಫ್ ವಿದೌಟ್ ಲುಕಿಂಗ್ ಇನ್ ಟು ದ ಅದರ್ ಪಾಯಿಂಟ್ಸ್, that point is a preliminary point. Okay. There is one case, DP Singh versus State of Uttar Pradesh, when he applied for bail before the court and the reasons were stated for not granting bail, but the court said that not necessary to look into all that, it was outright, it was dismissed, and then it came to appeal. This was the Allahabad High Court decision, when the preliminary point was that whether it is within the limitation or not. So limitation ಬಿಟ್ಟು ಅವನ ಬಂದಾಗ ಏನು, ಇಟ್ ವಾಸ್ ಎ ಕೇಸ್ ವೇರ್, of course you may say that how does the limitation apply here? See, there are limitations when it is a very time has been lapsed from that point till the point when it comes before the court. So at the earliest it has to come before the court. And also looking into the other points, the court said that it is not necessary for any other points to be decided. On the preliminary point itself it has been decided and the appeal was dismissed in this case. Now let us explain with the help of examples. The preliminary point may be a point of fact, it may be a point of law. ಈ ಪ್ರಾಥಮಿಕ ಪಾಯಿಂಟ್ ಏನಿದೆ ಅದು ಸಂಗತಿ ಮೇಲೆ ಆಧಾರಿತ ಇರಬಹುದು ಅಥವಾ ಕಾನೂನದ ಮೇಲೆ ಆಧಾರಿತ ಇರಬಹುದು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಲಾ ನೋಡಿದರೆ, ಇಫ್ ಯು ಲುಕ್ ಇನ್ ಟು ದ ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ, ವಿ ನೋ ದ್ಯಾಟ್ ದ ಪಾಯಿಂಟ್ಸ್ ಆರ್ in a preliminary decree. It says if the limitation, it is barred by limitation, or it is res judicata, or there is no cause of action, on that ground it can be dismissed or the decree can be passed, preliminary decree can be passed. Suit not maintainable. Why it is not maintainable? According to the law. In such cases, just on that ground only it may be dismissed. Then barred by limitation. If the suit is barred by limitation, the trial court can just dismiss the case. If it is res judicata also, it is a bar on trying the suit, so it can be dismissed. Now disclosing no cause of action, there is no cause of action, there is no suit. So if these are all points of law, now this has to be looked into by the appellate court whether this is properly taken, that's all. If the suit is not maintainable according to the grounds, or whether it is barred by limitation, that will be looked into by the higher court or by the appellate court. Okay, these are the points of law. What are the points of fact? See, there are several facts. The plaintiff may be estopped. There may be a principle of estoppel. He has stated something earlier and then now he cannot prove his case. On that ground only the court dismisses. Or the case was motivated. It finds some things where the plaintiff has a malified intention. So on that ground itself it dismisses. It doesn't look into the other cases at all, other points at all. Then if the plea is raised at the hearing ವಿಚ್ ಇಸ್ ಡಿಫ್ರೆಂಟ್ ಫ್ರಮ್ ದ ಪ್ಲೀ ರೇಸ್ ಇನ್ ದ ಪ್ಲೇಂಟ್. ಪ್ಲೇಂಟಲ್ಲಿ ಒಂದು ಪ್ಲೀ ಹೇಳಿರ್ತಾರೆ ಮತ್ತು ಹಿಯರಿಂಗಲ್ಲಿ ಬೇರೆ ಪ್ಲೀ ಹೇಳಿರ್ತಾರೆ. ಸೊ ಅದರಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ಅನಿಸುತ್ತೆ ಇದನ್ನು ಈ ಪಾಯಿಂಟ್ಸ್ ಬೇರೆ ಇದೆ, ಫ್ಯಾಕ್ಟ್ಸೇ ಬೇರೆ ಇದೆ, ಪ್ಲೇಂಟಲ್ಲಿ ಹೇಳಿರುವಂಥ ಸಂಗತಿನೇ ಬೇರೆ, ಅವ್ನು ಹೇಳ್ತಾ ಇರೋದೇ ಬೇರೆ ಅಂಥ ಪಾಯಿಂಟಲ್ಲಿ ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಆಗಿದರೆ, ಇದು ಅಪೀಲ್ಗೆ ಬಂದಾಗ ಆ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ ಮೇಲೆ ಮಾತ್ರ ಬರುತ್ತೆ ಅದು. ಸೊ ಇನ್ ಸಚ್ ಕೇಸಸ್ it has to be decided. In such cases the court may look into, the appellate may look into this particular case and decide whether it has to be reversed and whether it has to be sent on remand. Now first thing is the decree must have been reversed. That is the first condition for remand. So unless the decision of the lower court is reversed in appeal, it cannot be remanded to the trial court. This is the case Purappa Buchi Rama versus Purappa Vimala Kumari, Andhra Pradesh court decision, wherein they asked for the right of preemption right ಬೇಕಾಗಿತ್ತು. ಇದರಲ್ಲಿ ಮೊದಲು ಸೇಲ್ ಮಾಡೋ ಅಧಿಕಾರ ಏನಿದೆ ಇವ್ರಿಗೆ ಆಗಬೇಕು ಅಂತ ಹೇಳಿ ಅದರ ಒಂದು ಕಸ್ಟಮರಿ ರೈಟ್ ಇತ್ತು. ಅದ್ರ ಬಗ್ಗೆ ಆ ಕಸ್ಟಮರಿ ರೈಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಫೈಂಡಿಂಗ್ ಕೊಟ್ಬಿಟ್ಟು ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದರು. ಹಿಯರ್ first of all the court reverses, it has to reverse. Now where it was not reversed, the court says that first it must be reversed, then the preliminary point can be taken. So the whatever the preliminary point has been given in the lower court, the higher court or the appellate court must first reverse that point, and then it can remand to the court for collecting for evidence or any other reason for remand. Now next is, in the interest of justice also, even though there is not a preliminary point dismissal, it is a dismissal on the merits also, still the appellate court is empowered to remand a case. When the lower court otherwise than a preliminary point also has looked into it and it has dismissed the case, or any fact is to be elaborated in the interest of justice. Okay, in Dwarkaram versus Ramarati Devi, the appellate court said that is the Supreme Court said that when the court disposes of the case and in the interest of justice it is necessary, even on the preliminary point, ಏನಾಗಿರುತ್ತೆ, ಹೈ ಕೋರ್ಟ್ ಏನು ಮಾಡುತ್ತೆ, it has taken the case and without it had come to the high court not on the preliminary point dismissal, but it was dismissed by on merits, and the court had reversed the decision. So here the court says, Supreme Court says that this is a amendment which has been inserted in 1976, which gives the power to the appellate court to remand the case to the lower court even if it is not decided on a preliminary point, because earlier only on preliminary point the appellate court had the powers to remand. So what happened is there used to be a number of cases pending, and therefore it was very difficult for the appellate court to decide, because when it is decided otherwise than a preliminary point also, there are several cases where it comes in appeal. Then there used to be, before the Supreme Court, there used to go in appeal under Article 136. ಇಲ್ಲಿ ಈ appellate court ತಗೊಂಡಿಲ್ಲ ಅಂದರೆ ಸ್ಪೆಷಲ್ ಲೀವ್ ಟು ಅಪೀಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೀವಿ. ಸೊ 136 ಪ್ರಕಾರ ಹೋಗೋ ಇದನ್ನು ಜಾಸ್ತಿ ಆಗೋಯ್ತು, ಕೇಸಸ್ ಜಾಸ್ತಿ ಆಗೋಯ್ತು. ಯಾಕೆಂದರೆ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಬರೀ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆದರೆ ಮಾತ್ರ ಲೋವರ್ ಕೋರ್ಟ್ ಆವಾಗ ಮಾತ್ರ ಅದು ತಗೋಬೋದು, ರಿಮಾಂಡ್ಗೆ ಕಳಿಸ್ಬೋದು. ಈಗ ರಿಮಾಂಡ್ಗೆ ಕಳಿಸೋದು ನೆಸರಿ ಇದ್ದರೆ ಅದನ್ನು ಮಾಡ್ತಾ ಇರಲಿಲ್ಲ. ಸೊ ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತಾ ಇದ್ರು. ಸೊ ಟು ಸ್ಟಾಪ್ ದಿಸ್ ಆ್ಯಂಡ್ ಟು ಸಿ ದಟ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಈಸ್ ಗಿವೆನ್ ಮೋರ್ ಪವರ್ಸ್, ದಿಸ್ ವಾಸ್ ಇನ್ಸರ್ಟೆಡ್ ಇನ್ 23A was inserted by the Amendment Act of 1976, so that the appellate court can remand a case in the interest of justice even if the lower court decides on some other point, not a preliminary point, okay, on merits, that is. Then now what is the effect of a remand? Once the remand is made, it reverses the decision of the lower court, that we have seen. ಕೆಳ ಕೋರ್ಟಿನ ಡಿಸಿಷನ್ ರಿವರ್ಸ್ ಆಗಿ ಹೋಗುತ್ತೆ. ಸೆಕೆಂಡ್ಲಿ, ಇಟ್ ರಿಓಪನ್ಸ್ ದ ಕೇಸ್ ಫಾರ್ ರೀಟ್ರಯಲ್ ಬೈ ದ ಲೋವರ್ ಕೋರ್ಟ್. ಲೋವರ್ ಕೋರ್ಟಲ್ಲಿ ಆ ಕೇಸು ಮತ್ತೆ ರಿಓಪನ್ ಆಗುತ್ತೆ, ಮತ್ತೆ ಶುರು ಆಗುತ್ತೆ. ಮತ್ತು ಎಕ್ಸೆಪ್ಟ್ ಇನ್ ರಿಗಾರ್ಡ್ ಟು ದ ಮ್ಯಾಟರ್ಸ್ ಡಿಸೈಡೆಡ್ ಬೈ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಯಾವ್ಯಾವುದೋ ಮ್ಯಾಟರ್ಸ್ ಡಿಸೈಡ್ ಮಾಡಿದೆ ಅದನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಮ್ಯಾಟರ್ಸು ಲೋವರ್ ಕೋರ್ಟ್ಗೆ ಹೋಗುತ್ತೆ. then the court which is to which the case is remanded is bound by it. It cannot say no. ರಿಮಾಂಡ್ ಹೋದಾಗ ನಾನು ಮಾಡಲ್ಲ ಅಂತ ಕೆಲ ಕೋರ್ಟ್ ಹೇಳೋಕ್ಕಾಗಲ್ಲ. ಸೊ ಆವಾಗ ಏನಾಗುತ್ತೆ, ಇಟ್ ಈಸ್ ಎ ಡೈರೆಕ್ಷನ್ ಬೈ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ದೆನ್ ರಿಮಾಂಡ್ ನಲಿಫೈಸ್ ದ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ ಅದು ನಲಿಫೈ ಆಗಿರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಆರ್ಡರ್ ಬಂದಿರುತ್ತೆ, ಅದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಹೋದಾಗ ಅದನ್ನು ರಿಮಾಂಡ್ ಮಾಡಿದಾಗ ಇಫ್ ಇಟ್ ಕಮ್ಸ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ದ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಕ್ಯಾನಾಟ್ ಬಿ ಲುಕ್ಡ್ ಇನ್ ಟು. ಮೊದಲು ಕೊಟ್ಟಿರೋ ಆರ್ಡರ್ಗೆ ಬೇಸಿಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಅದು ನಲಿಫೈ ಆಗೋಗಿರುತ್ತೆ. ದೆನ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಶಾಲ್ ಫಿಕ್ಸ್ ಅ ಡೇಟ್ ಫಾರ್ ಅಪಿಯರೆನ್ಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ರಿಮಾಂಡ್ ಮಾಡುವಾಗ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡುತ್ತೆ, ಈ ಪಾರ್ಟೀಸು ಲೋವರ್ ಕೋರ್ಟ್ ಹತ್ರ ಅಪಿಯರ್ ಆಗಬೇಕು, ಹಾಜರಾಗಬೇಕು ಅಂತ. ಸೊ ದಿಸ್ ಇಸ್ ದ ಇಫೆಕ್ಟ್ ಆಫ್ ರಿಮಾಂಡ್. ಆ್ಯಂಡ್ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ರಿಮಾಂಡ್ ಈಸ್ ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್. If you are not agreeing with the grounds of remand, then you can go in appeal on this order also. Okay. Now the next power of the appellate court is power to frame issues and refer them for trial. Okay. Power to frame issues and refer them for trial. This is under Rule 25 of Order 41, 107 1C. So where the court from whose decree the appeal is preferred has omitted to frame the issue or has omitted to try an issue. ಯಾವುದೇ ಒಂದು ವಿವಾದದ ಪ್ರಶ್ನೆಯನ್ನು ಫ್ರೇಮ್ ಮಾಡೋಕ್ಕೆ ಆಗಲಿಲ್ಲ ಆ ಕೋರ್ಟ್ಗೆ. ಐ ಥಿಂಕ್ ಐ ಹ್ಯಾವ್ ಡಿಸ್ಕಸ್ಡ್ ವಿತ್ ಯು ವೆನ್ ವಿ ವೇರ್ ಡಿಸ್ಕಸಿಂಗ್ ಅಬೌಟ್ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಇಶ್ಯೂಸ್ that sometimes the court does not frame the issue which is there between the parties, and that at that time I said that you can either go in appeal or the party or the pleaders can frame the issue and file an application before the trial court also. We had discussed this part. So if the trial court does not frame an issue which is required, which is necessary to be framed, and for the right decision of the suit that issue is necessary, if the appellate court thinks that, then it can refer them to the trial court. It can itself frame the issues. ಈಗ ಲೋವರ್ ಕೋರ್ಟ್ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿಲ್ಲ, ಅದು ಅವಾಯ್ಡ್ ಮಾಡಿದೆ ಅಥವಾ ಒಮಿಟ್ ಮಾಡಿದೆ, ಅದನ್ನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಏನು ಮಾಡ್ಬೋದು, ಅದೇ ಇಶ್ಯೂ ಅದೇ ವಿವಾದದ ಪ್ರಶ್ನೆಯನ್ನು ತಾನು ಫ್ರೇಮ್ ಮಾಡಿ ಅದನ್ನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ರೆಫರ್ ಮಾಡಿ ಈ ಇಶ್ಯೂ ಮೇಲೆ ನೀವು ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಳಿ. ಸೊ ಇಟ್ ಮೇ ಆಸ್ಕ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟು ಟೇಕ್ ದ ಎವಿಡೆನ್ಸ್ ಆನ್ ದೋಸ್ ಇಶ್ಯೂಸ್ ವಿಚ್ ಇಟ್ ಹ್ಯಾಸ್ ಫ್ರೇಮ್ಡ್. So then the lower court is bound. It will try those issues and return the evidence to the appellate court within the time fixed. So the decision will be given by the appellate court, but it will send it to the trial court to look into that matter and send it back. See, there is a difference here in the order of remand and the order of framing the issues. So what is the difference is, here the issues are framed by the court itself, and the court and the trial court only takes the evidence, that is it takes additional evidence which is required and it will send it back to the appellate court, wherein in remand it will send it back for a particular purpose and that has to be done by the trial court itself. So here the power goes to the appellate court only, wherein there it is exercised by the trial court. Whatever the directions is given by the appellate court, according to that it will look into the matter. So there is a difference between Rule 24 and Rule 25, 23 and 25. Then that is the power to frame issues. Here Rule 26 speaks about the findings. Now the evidence and findings in that case, when the framing of issues has been done, that findings will form part of the record in the suit, and either party may present a memorandum of objections to that finding. So when that framing of issues is done, there are findings in that case. So in that findings, either of the party, if they don't agree with the findings, they can file a memorandum of objections. Therefore the appellate court will give a time to file the memorandum of objections. ಈ ಥರ ಫ್ರೇಮ್ ಇಶ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದರೆ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್, ಅದರಲ್ಲಿ ಒಂದು ಫೈಂಡಿಂಗ್ ಇರುತ್ತೆ, ಈ ಬೇಸಿಸ್ ಮೇಲೆ ಇಶ್ಯೂಸ್ ಆಗಬೇಕು. ಸಿ ಇಶ್ಯೂಸ್ ಆರ್ ಆಲ್ವೇಸ್ ವೆನ್ ವಿಚ್ ಆನ್ ದ ಕಂಟೆನ್ಷನ್ಸ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್ ಏನು ಕಂಟೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ಅದ್ರ ಮೇಲೆ ಇಶ್ಯೂಸ್ ಆಗುತ್ತೆ. ಸೊ ಇದನ್ನು ಅವ್ರು ಅಗ್ರಿ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಯಾವುದೇ ಪಾರ್ಟಿ, ಅದನ್ನು ಅವರು ಒಂದು ಆಬ್ಜೆಕ್ಷನ್ಸ್, ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬೋದು ಆ ಫೈಂಡಿಂಗ್ಗೆ. Then after the time is over for presenting that memorandum for against that finding, then the appellate court shall proceed to determine the appeal. ಇದನ್ನು ಆದಮೇಲೆ ಫ್ರೇಮಿಂಗ್ ಇಶ್ಯೂಸ್ ಆದಮೇಲೆ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡಿದ್ಮೇಲೆ ಈ ಟೈಮ್ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋ ಟೈಮ್ ಮೀರಿದ ಮೇಲೆ ಅದನ್ನು ಮುಂದೆ ನಿರ್ಣಯ ತಗೋಬಹುದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ಸೊ ದಿಸ್ ಇಸ್ ಅ ಸ್ಪೆಷಲ್ ಪವರ್ ಆಫ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಟು ಫ್ರೇಮ್ ಇಶ್ಯೂಸ್ ಆ್ಯಂಡ್ ರೆಫರ್ ದೆಮ್ ಫಾರ್ ಟ್ರಯಲ್. ನೆಕ್ಸ್ಟ್, the appellate court has a very important power to take additional evidence or require such evidence to be taken. So what happens normally is, in the appellate court no evidence is taken additionally. They shall not be entitled to produce additional evidence, whether it is oral evidence or documentary evidence in the appellate court. ಅಪೀಲ್ ಕೋರ್ಟಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಮೌಖಿಕ ಆಗಲಿ ಅಥವಾ ದಸ್ತಾವೇಜಾಗಲಿ ಯಾವುದೇ ಒಂದು ಸಾಕ್ಷಿ ನಂತರ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಆಗೋಗಿರುತ್ತೆ, ಅದನ್ನು ಮತ್ತೆ ಇನ್ನೊಂದು ಸತಿ ಅಥವಾ ಬೇರೆ ಏನಾದರೂ ಅಡಿಷ್ನಲ್ ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಳೋಕ್ಕೆ ಪರ್ಮಿಷನ್ ಇರೋದಿಲ್ಲ ಸಾಮಾನ್ಯವಾಗಿ. ಬಟ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಮೇ ಅಲೌ ಸಚ್ ಎವಿಡೆನ್ಸ್ ಬೇಸ್ಡ್ ಆನ್ ಸರ್ಟನ್ ಕಂಡೀಷನ್ಸ್. ಕೆಲವು ಸಂದರ್ಭಗಳಲ್ಲಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅದನ್ನು ಎವಿಡೆನ್ಸ್ ಅಲೌ ಮಾಡ್ಬೋದು. ಸಿ ದಿಸ್ ಇಸ್ ಅ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವೆಶ್ಚನ್. ಸಮ್ಟೈಮ್ ದಿಸ್ ಕ್ವೆಶ್ಚನ್ ಈಸ್ ಆಸ್ಕ್ಡ್ ಆಸ್ ಎ ಸೆಪ್ರೇಟ್ individual question in the exams also. What is the discuss the power to take additional evidence of this of the appellate court. So this is a very important power, because normally no additional evidence is allowed in the appellate court. On what conditions the appellate court can take? So these are the conditions. The court from whose decree the appeal has been preferred, it should have refused to admit evidence which ought to have admitted. ಅಂದರೆ ಇಫ್ ಆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿರುವಾಗ ಕೆಲವು ಸಾಕ್ಷಿ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಪಾರ್ಟೀಸ್ ಹೇಳಿದ್ದಾಗ ಆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆ ಸಾಕ್ಷಿಯನ್ನು ತಗೊಳ್ಳದೇ ಇರಬೇಕು. ಆಗ ಅದನ್ನು ಆ ಪಾಯಿಂಟ್ ನೀವು ಅಪೀಲಲ್ಲಿ ಹೇಳಿದರೆ ಈ ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ಬೋದು, ಅದನ್ನು ರಿಮಾಂಡ್ ಮಾಡ್ಬೋದು, ಅಥವಾ ತಾವೇ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ತಗೋಬೋದು ಕೋರ್ಟ್. ವೆನ್ ದ ಕೋರ್ಟ್ comes to know that the trial court has not admitted evidence, it has refused to admit evidence which ought to have been admitted. There may be some necessary evidence which was to be produced, but the trial court has not admitted that evidence. Then this is a condition for production of additional evidence. Then the party should also prove, or should say that in spite of due diligence, that evidence was not in its knowledge at the time when the decree was passed by the trial court. ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಡಿಗ್ರಿ ಪಾಸ್ ಆದಾಗ ಈ ಸಾಕ್ಷಿ ನನ್ನ ಹತ್ರ ಇರಲಿಲ್ಲ, ಈ ದಸ್ತಾವೇಜ್ ನನ್ನ ಹತ್ರ ಇರಲಿಲ್ಲ, ಈ ಎವಿಡೆನ್ಸ್ ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ, ಐ ಡಿಡ್ ನಾಟ್ ನೋ, ಇಟ್ ವಾಸ್ ನಾಟ್ ವಿದಿನ್ ಮೈ ನಾಲೆಜ್. ಮೇ ಬಿ ಸಮ್ ಪರ್ಸನ್ he finds a will later on, that will he did not know about. So when if he is not allowed to produce it before the trial court, he goes to the trial court and says that I want to produce it. The court does not give him permission because already it is the stage of argument. In such cases it is necessary because it may change the outcome of the case. So in spite of my due diligence, ನಾನು ಅಷ್ಟು ಕಾಳಜಿ ತಗೊಂಡಿದ್ರು ಅದನ್ನು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋಕ್ಕೆ ಆಗ್ತಿರಲಿಲ್ಲ ಅಂತ ಹೇಳಬೇಕು ಅಂತ ಒಂದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಗೊತ್ತಾಗಬೇಕು. Then the appellate court itself may require any document to be produced or any witness to be examined to pronounce judgment. ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಅನ್ನಿಸ್ಬೇಕು ಯಾರೋ ಒಬ್ಬ ವಿಟ್ನೆಸ್ ಬೇಕಾಗಿದೆ ಅಥವಾ ಯಾವುದೋ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು, ಅದರಿಂದ ಈ ನಿರ್ಣಯ ಸರಿಯಾಗಿ ಕೊಡ್ಬೋದು, ಆಗ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ಗೆ ಕಾಲ್ ಮಾಡ್ಬೋದು, ತಗೋಬಹುದು. ವೆನ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಥಿಂಕ್ಸ್ ದಟ್ ಸಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ನೆಸಸರಿ ಟು ಪ್ರೊನೌನ್ಸ್ ದ ಜಜ್ಮೆಂಟ್ ಆನ್ ದ ಇಶ್ಯೂ, then it can ask for the additional evidence. Then or any other substantial cause, this is a you call it as a general cause or general reason, any other cause which is necessary for allowing the evidence. If the appellate court comes to know about it or thinks about it, then it can allow production of additional evidence. Now when it allows production of additional evidence, reasons must be recorded when it is allowed. This is very important because if you decide to go in a second appeal also, those reasons are there why the additional evidence is allowed. So this is a condition for production of additional evidence. There is a very important case in this case, in this circumstances we can discuss, that is Shivaji Rao Nilangekar versus Mahesh Madhav, in which the conditions for production of additional evidence has been discussed in detail by the Supreme Court in this case. In this case it was a question of a lady who was a daughter of the erstwhile Chief Minister of Maharashtra, and she appeared for the medical exam. that was Shivaji Rao Nilangekar versus Mahesh Madhav. Here what happened, there was an allegation that the chief minister, because it is his daughter, she has failed 3 times in the exams, but to allow her to pass, he has gone to the extent of assisting her by directing several authorities to tamper with her papers, that is her ಕ್ವಾಲಿಫಿಕೇಷನ್ಸ್. ಅವಳ ಕ್ವಾಲಿಫಿಕೇಷನ್ಸ್ ಏನಿದೆ, ಅವಳು ಪಾಸ್ ಆಗಿರೋದು, ಮುಂಚೆ 3 ಸತಿ ಫೇಲ್ ಆಗಿರೋದು, ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸನ್ನು ಟ್ಯಾಂಪರ್ ಮಾಡೋಕ್ಕೆ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಒಂದು ಹೆಲ್ಪ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅಲಿಗೇಷನ್ಸ್ ಇರುತ್ತೆ ಇದರಲ್ಲಿ. ಅವರ ಡಾಟರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮ್ಗೆ ಕೂತಿರ್ತಾಳೆ. ಸೊ ದಿಸ್ ಇಸ್ ದ ಕೇಸ್ ವೇರ್ ಇನ್ the other party, that is Mahesh Madhav, he speaks before the trial court that he wants to produce the evidence which is showing that the chief minister has done these things. Idak munche in several cases before this also he has done it. He wants to show that evidence. Now the trial court dismisses that appeal. It comes to the appellate court. In this case, the court says that, see, while additional evidence is allowed, in this case whether additional evidence can be allowed or not, that is the question. So it is whether it is necessary for deciding the facts of the case. There the court says that when it is necessary, when it even for any substantial cause, if it is necessary for producing additional evidence, then the court must allow the production of additional evidence. It should not say no for producing the additional evidence. This is the case. Then what is the mode of taking additional evidence? How can it be taken? See, the appellate court under Rule 28 may either take the evidence itself, or it may direct the court from where the decree has been preferred, or to any other subordinate court to take evidence and send it to the appellate court. ಯಾವುದೇ ಒಂದು ಎವಿಡೆನ್ಸ್ ತಗೋಬೇಕಾದ್ರೆ ತಾವೇ ತಗೋಬಹುದು ಅಥವಾ ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಆದೇಶ ಕೊಡಬಹುದು, ನೀವು ಇದನ್ನು ಎವಿಡೆನ್ಸ್ ತಗೊಂಡು ನನ್ನ ಕಡೆ ಕಳಿಸಿ. ಸೊ ದಟ್ ಈಸ್ ದ ಪವರ್ ಆಫ್ ದ appellate court again. Now where additional evidence is directed to be taken, then what happens, what points the evidence has to be confined to, that has to be specified by the appellate court. It should say that ಯಾವ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇದನ್ನು ಎವಿಡೆನ್ಸ್ ತಗೋಬೇಕು. It has to say on which point the evidence is called for, and then the whatever the evidence comes in, it will record on its proceedings on those points the evidence has been taken. ಯಾವ ಪಾಯಿಂಟ್ಸ್ ಯಾವ ಎವಿಡೆನ್ಸ್, it has to be recorded. On what points what evidence, it has to be recorded before the appellate court. That is Rule 29. Now this is the power to call for additional evidence. Now power to modify the decree. There is one special provision in CPC, that is Rule 33 under Order 41, which gives the power to the appellate court to modify a decree. ಒಂದು ಡಿಕ್ರಿ ಪಾಸ್ ಆಗಿರೋದನ್ನು ಅದನ್ನು ಮಾಡಿಫೈ ಮಾಡೋದು, ಚೇಂಜ್ ಮಾಡೋದು ಯಾವಾಗ ಸಾಧ್ಯ ಇದೆ ಅಂತ ನಾವು ನೋಡ್ಬೋದು. ಈ ಪವರ್ ರೂಲ್ 33ನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಹೇಳಿದ್ದಾರೆ. ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಕಸ್ ಒನ್ ಕೇಸ್, ಪನ್ನಾಲಾಲ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಾಂಬೆ. ದಿಸ್ ಹ್ಯಾಸ್ ಬೀನ್ Rule 33 has very nicely been explained in that case. The appellate court has power to make whatever order it thinks fit, not only between the appellant and respondent, but also between one respondent and another respondent. Anything, the appellate court has a power to make any order to or modify that case. It may be between the appellant and respondent only, or even one respondent and another respondent also. The appellate can take court can make an order, and the appellate court can give relief or refuse relief to the appellant. It may allow the appeal, it may dismiss the appeal. It may give relief to any of the respondents as the case may require. So this is a very wide power in the hands of the power of court of appeal. It shall have power to pass any decree, make any order which ought to have been passed. See, the word says ought to have been passed, and as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondent of parties. Suppose only one part of the decree has been challenged before the appellate court, but the court wants to give the decision and give the relief to all the respondents, then also it can do so. Although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits or 2 more decrees are passed in one suit, be exercised in respect of all of such decrees, although an appeal may not have been filed against such decrees. It is a very wide power, Rule 33. So, whatever has, even if a appellant appeals on one part of the decree and does not appeal on another part of the decree, it can look into the other part also and grant the relief to the respondents. If one respondent has not filed an objection and he has not filed another suit also, then also it can modify the decree. This is the meaning of Rule 33, which was discussed in Pannalal versus State of Bombay. We have discussed this. Pannalal was a contractor who constructed 3 buildings of hospitals, and there were different defendants. He has included number of defendants. Out of that, the case was dismissed against all of the defendants except one, that is a state of MP, where it was decided, that is the case is a place in MP. So, there the court, in this case the appellate court, decided to modify the decree in favor of the respondents who had not appeared before the court or who had not preferred an appeal. In this case, the court looks into the scope of the power of Rule 33. What is the scope of the power is, it says that which ought to have been passed, or such order which ought to have been passed, and it can be exercised notwithstanding that appeal is part of the decree. But the court again says that when the person has not applied, he had an opportunity to file a cross objection, he has not filed a cross objection. He had a opportunity to file a appeal, he has not filed appeal. So, the relief cannot be given to the other persons, other defendants, but here according to 33, if the Supreme Court or the appellate court thinks that it is necessary in the particular case, then it can even give the relief to the persons who have not appeared. So, in this case, the appeal was dismissed against all of the defendants. One defendant was before the court, or one respondent was before the court, but it was the relief was given to all in this case. This is a very important case relating to power of modifying the decree. So, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನು ಮಾಡಿದ್ರು, ಇವಾಗ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಏನು ಮಾಡೋದು ಅವಶ್ಯಕತೆ ಇದೆ ಅದನ್ನು ನೋಡಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಒಂದು ವೈಡ್ ಪವರ್ ಇದೆ, ಅದನ್ನು ಚಲಾಯಿಸಿ ಆ ಡಿಕ್ರಿನ ಮಾಡಿಫೈ ಮಾಡಬಹುದು. So, there is an illustration for this. There are 2 illustrations in fact. A claims a sum of money due from him from X or Y. Now, in that A obtains a decree only against X. X goes in appeal. Now, A and Y both are respondents. He goes in appeal. Appellate court decides in favor of X. It has power to pass a decree against Y also. Y is a respondent before the court. So, it can modify the decree in such a way that against Y also he can, because only the decree was against X, but the appellate court has a power to pass a decree against Y also. Then same way, if the amount is due from X or Y, suit is partly against X, partly against Y. X appeals, Y does not appeal. Now, here the party is not before the court. Still the appellate court can discharge X by making Y liable for the whole amount. Though Y is not an appellant, still the power can be modified in such a way, that is the decree can be modified in such a way that Y can be made liable, he is not before the court. That is the wide power of Rule 33. Okay. Now, what is this objective of Rule 33 is to enable the appellate court to do full and complete justice between the parties. ಯಾವುದೇ ಪಾರ್ಟಿ ಬಿಟ್ಟೋಗಿದೆ ಆ ಪಾರ್ಟಿಗೆ ಜಸ್ಟಿಸ್ ಆಗಬೇಕು ಅಂತ ಇದ್ದಾಗ ಈ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್, ದಿಸ್ ಇಸ್ ರೂಲ್ 33 ಇಸ್ ಎ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್, ಈ ವಿವೇಚನಾಧಿಕಾರ ಚಲಾಯಿಸಿ ಆ ಕೇಸಲ್ಲಿ ಇರುವಂಥ ಎಲ್ಲ ಪ್ರಶ್ನೆಗಳನ್ನು ಡಿಟರ್ಮಿನ್ ಮಾಡೋ ಪವರ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಇದೆ. ಸೊ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಎ ಪವರ್ to determine all questions, so that it should not be once again it should not be agitated by the parties. So, to do complete justice between the parties, the appellate court has a power to decide the matter completely, and therefore it can give any it can modify the decree to any extent, giving relief to anybody even if he is not before the court, even if he is a co-respondent, even if he has not filed objections, even he is not filed an appeal. Then also it specifies, Rule 33 specifies that all as the case may require to pass orders further or any other decree. Any other decree andre eno, ee decree bittu bere decree pass madabodu. So, it can replace that decree. That is the wideness of Rule 33. Now, what are the conditions for exercise of power? is that first of all the parties before the lower court must be there before the appellate court. But in this case even that was not there. The question raised must have properly arisen out of the judgment of the lower court. Lower court ಏನು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರ ಪ್ರಕಾರ ಆ ಪ್ರಶ್ನೆ ಬಂದಿರಬೇಕು. If these questions are fulfilled, these conditions are fulfilled, then the appellate court can consider any objection against any part of the judgment or decree of the lower court. Lower court decree ಇಂದ ಏನಾದರೂ objection ಇದ್ದರೆ appellate court ಮುಂದೆ ಫೈಲ್ ಮಾಡಿದರೆ ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು. ಈ ಕಂಡೀಷನ್ಸ್ ಫುಲ್ಫಿಲ್ ಆಗಬೇಕು. ಅಕಸ್ಮಾತ್ ಆ ಅಪೆಲೆಂಟ್ ಬಂದು ಅವನು ಇದನ್ನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಂಡಿಲ್ಲ, ಇದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಿದಾಗ ಅದನ್ನು ಎಕ್ಸಸೈಸ್ ಮಾಡೋಕ್ಕೆ ಪವರ್ಸ್ ಇದೆ. ದೀಸ್ ಆರ್ ದ ಕಂಡೀಷನ್ಸ್ ಟು ಎಕ್ಸಸೈಸ್ ದಿಸ್ ಪವರ್ ಅಂಡರ್ ರೂಲ್ 33. Okay, then the last one is other powers. What are the other powers? See, as any other original court has a different powers, same way the appellate court has also powers just as an original court. That is, it can do whatever the original court would have done while the suit was pending. So, what are the things which it can do? It can reappreciate the evidence once again. It can transpose or substitute the parties. It can permit the withdrawal of the proceedings before the appellate court. It can do so because a trial court can do so. Then it can return a memorandum of appeal for presentation to the proper court, just as the return of the plaint is done. Then it can allow amendments. It can take notice of subsequent events. ನಂತರ ಬಂದಿರುವಂಥ ಈವೆಂಟ್ಸನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಒಂದು ಆದೇಶ ಕೊಡ್ಬೋದು. ಇಟ್ ಕ್ಯಾನ್ ಟೇಕ್ ಇನ್ ಟು ಕನ್ಸಿಡರೇಷನ್ ಅ ಚೇಂಜ್ ಆಫ್ ದ ಲಾ ಏನಾದರೂ ಚೇಂಜ್ ಆಗಿದ್ದರೆ, ಕಾನೂನು ಚೇಂಜ್ ಆಗಿದ್ದರೆ ಅದನ್ನು ಗಮನಕ್ಕೆ ತಗೋಬಹುದು. ಆರ್ಡರ್ ರೆಸ್ಟಿಟ್ಯೂಷನ್, ಆ ಕೇಸಲ್ಲಿ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಕೊಡಬಹುದು, ಪುನಃ ಸ್ಥಾಪನೆ ಮಾಡ್ಬೋದು. ಇದೇ ರೀತಿ ಹಳೆ ಕೆಳಗೆ ಕೋರ್ಟ್ಗೆ ಏನೇನು ಪವರ್ಸ್ ಇದೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋ ಪವರ್ಸು ಅಥವಾ ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಳೋ ಪವರ್ಸು, ಅಪ್ರಿಷಿಯೇಷನ್ ಮಾಡೋ ಪವರ್ಸು, ಏನೇನು ಪವರ್ಸ್ ಇದೆ, ಮತ್ತು ಒಂದು ಪಾರ್ಟಿ ಜಾಗದಲ್ಲಿ ಇನ್ನೊಂದು ಪಾರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಪೋಸ್ ಮಾಡೋ ಪವರ್ಸು, ಆಲ್ ದೀಸ್ ಪವರ್ಸ್ ವಿಚ್ ಆರ್ ಎಕ್ಸಸೈಸೇಬಲ್ ಬೈ ದ ಲೋವರ್ ಕೋರ್ಟ್. ಸೆಕ್ಷನ್ 107 subclause 2 says that the appellate court has all the powers which a trial court may have in a suit. So, this is how there are the powers of the appellate court to look into the cases before it and decide the matter and give a decision. So, the key points what we decided here is, let us bring it that in one key point, that is the appellate court has complete discretionary powers. It can pass various orders in appeal, it can modify the decree, it can confirm the decree, it can reverse the decree. It can, based on the circumstances, take additional evidence. It can remand the case if necessary, and it can pass any orders which is necessary for that particular purpose. So, this is the points which we have discussed today in this discussion. Then, to summarize, the Civil Procedure Code provides for the discretionary powers of the appellate court to take decisions looking into the facts and circumstances when the case comes before it for appeal. All these powers are exercised according to the provisions of 107 and according to the provisions of Order 41 of the CPC. Now, in the next class, we will be looking into the duties of the appellate court. Of course, powers entitle for duties also. So, and afterwards, we will discuss how the judgment of the appellate court is passed and how the decree is passed. Just like the judgment and decree of the lower court which we have discussed, how the appellate court exercises its jurisdiction and passes a judgment and decree. These are the things which we will be considering in the next session. Any questions are there? Please, if you have any questions in this matter, you can raise the questions. You can just type it in the box here, or you can send your comments. You can share this with any of your friends who can make use of it. Yes, and we will meet again in the next discussion where we will be looking into the duties of the appellate court. Thank you.